Welcome to Let's Learn Legal. The information contained in this video is for general information purposes. Please consult an attorney in your area to understand how this information applies to you. In this video, I will explain the destination of assets. When people talk about estate planning, they usually think of a will. But did you know that when a person passes away, their assets will be distributed by 3 other methods before the will is even considered? The 3 methods are joint ownership with right of survivorship, beneficiary designation, and operating agreements and bylaws. Understanding these distribution methods is essential to creating an effective estate plan. To help explain this concept, let's chart our assets into categories. The first category is joint ownership. Joint ownership with right of survivorship is the most powerful and fastest method of distribution. By giving and sharing an asset with another person while you are alive, the asset automatically transfers to the survivor when you pass away. Joint ownership is typically shared between spouses when they take title on real estate, investments, checking accounts, and vehicles. While joint ownership does avoid probate, use caution. Sharing joint ownership may have severe tax consequences for both parties and may expose the asset to other owners, creditors, and liabilities. In addition, joint ownership with one child could result in you accidentally excluding your other children from inheriting. Do not use joint ownership with anyone outside of a spouse unless you have been advised of the potential tax consequences, liability and debt exposure, and the ultimate estate planning consequences. Even if you do share joint ownership on an account, you will still need to plan for how that asset will be transferred when both owners have passed away. The second category and method of distribution is beneficiary designation, or what we call PODs and TODs, pay on death and transfer on death designation. Beneficiary designations are most commonly used on checking accounts, savings accounts, life insurance, IRAs, 401ks, mutual funds, money markets, stocks, bonds, and CDs. The process to claim these assets after you die should be relatively simple. Your beneficiaries provide a bank a death certificate, and then the bank in turn gives them a claim form to fill out. The money is then transferred to those beneficiaries in the percentages you directed. Once again, no probate is required. These designations will be followed regardless of what your will says. The next category applies to those who own a business. If you own an LLC, S Corp, C Corp, partnership, or a nonprofit, your operating agreement or bylaw will direct how the assets owned by businesses will be distributed. Common business assets include real estate, account receivables, bank accounts, and equipment. Ideally, your operating agreement or bylaws will clearly state who is in charge of the business upon your passing and who the assets are distributed to upon dissolution. Once again, no probate is required. Finally, we have come to the will. Any assets that have not already been distributed by one of the 3 previous methods will be distributed by the will. A will is a legal document that is used to initiate probate by appointing an executor and then directing them on how to distribute the assets. If your estate meets certain requirements and involves no property, you may be able to still avoid probate by using a small estate affidavit. Probate is different in every state, but typically the process involves filing a series of documents with the courts, notifying creditors and beneficiaries, liquidating assets, and takes months if not years to finalize. Want to avoid probate? Trusts are a great method for not only avoiding probate, but they can also protect assets for beneficiaries who are minors, inexperienced with money, have disabilities, addiction, complicated family dynamics, or who are receiving government benefits. They can also be helpful in planning for blended families or large estates that want to avoid the death tax. So let's chart your estate plan. Using the form provided on my free resources page, list your assets, estimate their value, and write down who the intended beneficiaries are and what method of distribution you have in place to get the asset to them. Remember that the will is the last stop, last resort, and the weakest method of distribution. Thank you for taking this journey with me in exploring the destination of assets. Still have questions, or are you interested in learning more about starting a trust? Inquire before you hire. Seek a consultation with an attorney licensed in your state, and make sure your assets reach their proper destination.